America is a nation that can be defined in a single word. I was going to
I wanna fly like an eagle to the sea.
All right. Hello, everyone. Hope your day have been going well so far. So let's get it going. Okay, let me see here. I'm gonna mute everyone. Okay, the first number that I see here was 805-551. 805-551. What's going on?
Hello.
Hey.
Hey, Mohammed. It's Eddie from California.
Hey, Eddie.
How you doing?
Great.
I have a question. So finally, regarding my case where I'm doing constitutional challenge, so basically I ran out of time. I had a question. Is it still okay to file 10 days before the trial date is scheduled?
Yes, you can. It can be challenged at any time. Yeah.
Okay. So I'll do that. And then what should I expect, like, after I do the constitutional challenge? I put it on the record and send it to Attorney General. Are they going to notify me, or do I still have to show up for, like, that trial date?
Okay, so not even considering the time that it's going to take to get there and the time it's going to take for them to even open it and read it, I don't think that 10-day period is really going to be much of a use. Second is that usually what I've noticed is they respond differently when trial is closer because they would like to play hardball. But the thing is, what you can do is do a motion for continuance for the trial date under the assumption that, or under the presentation that you've yet to have all the necessary things to prove the case is constitutional or prepare for trial, and that there's still some challenges necessary before trials can really go on. That's what I would tell you to do.
Okay. All right. So I'll file it and just take it from there, I guess. Another question I have is also regarding constitutional challenge. So in the instruction down at the bottom where it says, here are two most important parts, the number 2 where it says, since the complaint bears on its face no actual laws being abrogated by the alleged defendant, that makes it easier.
This call is being recorded.
And you simply omit the title section referring to legislature if there's any later found out before sending them out, then add it and find the legislative equivalent. So regarding that title, so do I need to put that whole legislative, session? Because I found the equivalent, which was like Assembly Bill 1650, last amended in 2000, and basically that's where it mentions that section that they're charging me with the code. Hello?
Okay, one second. Let me open up the instructions to read what you're referring to. It's just a complaint bears on the face no actual law being abrogated by the alleged defendant. Then it makes it easier, and you simply put the title section referring to the legislature. If there's any later found out before sending them out, then add it and find the legislative equivalent. Yeah, you did just that. Yes.
So basically my title says, where it says notice by affidavit to estoppel, so I put basically constitutional challenge to administrative proceedings and California State Legislature AB 1650, year 1999 session, chapter 724 and section 41. And then vehicle code, vehicle division 11, rules of the road, section blah, 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 chapter 7, speed laws, section so and so.
Yes.
Is that okay?
Yes.
Okay?
Yes.
Okay. Cool. And what else? So regarding like judicial notice, mandatory judicial notice. So do I have to like number it as an exhibit, or I just kind of put it in and then it lists all the exhibits inside?
Okay, so in short, it's just going to tell them to take judicial notice of the following fact on the record as attached to below. And then you'll itemize the title of each document.
Okay, yeah, I did that. So if I want to add so initially I will file, all just the basic things for a constitutional challenge: denial of allegations, denial of citation, oath for the judge, motion to dismiss, copy of the Constitution. And so if I decide to add some more things to that case, do I do another judicial notice, or should I add all those items right away?
I mean, as things go on and you find that you have new things, then yes, add other items to a new judicial notice.
New judicial. Okay,
Yes.
cool. Okay, that will be all for me.
All right, the next number that I saw was 281660. 281660. Hey.
Hey there, can you hear me?
Loud and clear.
Okay, because I had muted. Let me see. My questions are about 508. Let me get to them here. How are you doing?
I'm great.
Good. Okay. So, 508, from my understanding, the 508 creates a tax shelter for a property. But does placing a lien on the property create the same protection from creditors in legal matters?
It does, but at some point, if you use an S Corp or C Corp, one, they can easily pierce it. So which makes the lien itself utterly useless because people can search the names of the owners of the business publicly. Even if you use Delaware or all the other states that don't necessarily do it publicly, so long as it's sharecrop with the state. So say you put the lien on a property using LLCs, whatever, S Corp, blah, blah, blah. Unless those entities that are public are owned as a single member managed by a trust that is confidential, or by a 508. But instead of doing that, just straight up use a 508.
Okay. So would it then be best to put the property in an irrevocable trust for that protection?
Yeah, you can do that if you want. There's nothing wrong with that.
Okay. All right. And then the other question is also 508. I can't read my writing here.
But let me just clarify before we move to the next question. If you do it with an irrevocable trust, the thing is, if someone ends up hiring a private investigator, and that private investigator at some point links you to that trust, it will be kind of sort of hard to say that you're not attached to it because it is irrevocable. Irrevocable trust cease to exist when things have decanted, so to say. So say that a irrevocable trust somehow at some point for whatever reason gets stuck in some type of litigation attached to the assumed creditor who wants to take the property. They'll then ask is, if you're saying, well, you're not attached to this irrevocable trust, well, who did you decant it to? Because you're already in the case and you're obligated to respond. But if it was a revocable trust, once you notice anything going worst case scenario, you can always abort the ship. It's the reason why it's revocable by you. So I would employ you to use a revocable trust rather than irrevocable. So in short, you can use a trust, but just try to make it revocable because it allows you to jump ships at any time, even if someone hires a private investigator to find you.
Okay. Okay. So then the other question is, with reference to the bylaws for the 508, are those bylaws written interchangeably based upon the usage of the bylaws?
No, the bylaws are fixed, but you can always add anything you want to it. Bylaws have the basic requirement for you to be able to make that 508 a business trust. So the Constitution itself is what ties it to a constitutional religious aspect. The bylaws is what makes it something called a business trust, which allows you to be able to use it to hold properties and be able to have a formal structure that is recognized as something that can be used in business. So you can add or remove it as you want. So it's up to you, really.
Okay, so I'm just presenting the bylaws for different situations. Like if I'm presenting the bylaws for like real estate, then the verbiage would be whatever it is. And then if I'm presenting it for something else, I don't know.
Yeah, so the
medical
bylaw,
or something.
yeah, the bylaw is useful for all those circumstances. It's created in a way whereby you can generally use it in any aspect of business. But if you find that a specific specialty of business requires some verbiage, you can add it. But outside of you adding anything else, it's already designed specifically to be used in any aspect of business.
Okay. All right, that's what I was kind of getting at. I was kind of confused with that. Yeah, and so then the final question was regarding the membership. So has your membership changed yet?
No, it hasn't. It's still there.
The membership cost.
Yeah, the cost is still there. Oh, that was you that emailed me. Okay, so for those who use Apple, Apple takes away their own fee. So do you use Apple? Like any Apple device?
I have I do have an iPhone, so maybe, yeah.
Yeah, so I think there was a post that I made last year. Go ahead.
Yeah, I saw that. Okay, so that's the situation.
Yeah, Apple takes their own fee out if you use the app using their device. So they add like an extra 13 to like 33%. So say you joined the tier 2, which is $60. Apple will add like 9 to like 33% of theirs if you downloaded it using their app store and you running it through their store. So they charge you for using their device, for using Patreon on their device. So that's why I just tell people, just log in on a laptop or a tablet, or just go on the website itself, patreon.com, so.
Don't even use the app from your phone?
I mean, you can, but I don't implore people to do so on Apple because Apple charge you for using Patreon on there.
Yeah, that's what I'm saying. In order to, right. So in order to eliminate that charge, it's best to not even do that on your phone. Gotcha. Okay. All right. Well, thanks so much.
All right. The next number that I saw was 919-634. 919-634. Hey, what's going on?
Hey, Mohammed.
Hey.
So I wanted to follow up with our most recent consultation where we were talking about how trademarks are applied onto the 508 when it comes to, like, purposes of like injunction. And you had mentioned how the express trust will be trademarking itself, and this is somehow transferred over to the 508. But we ran out of time on our call, and I didn't quite fully grasp the concept. I was wondering if you could further elaborate how that trademarking of the 508 works.
Yep. The way that it, in short, works or transfers to another entity is if the trademark entity, 123 Express Trust, does a business as any other name. In other words, all properties or association to the trademarked entity carries that same trademark capacity. Hey, I'm inviting you to come join the patron page. Not only do you get access to documents, posts, and videos that you will never find on any other platforms, you also get instant access to webinars that otherwise will cost far more. And we speak of things that usually we would not be able to speak of on any other platforms far more freely. On top of that, you get the opportunity to send me monthly questions. It is still that trademarked entity doing business. It's just doing it in a different name. And the interest of that DBA is also that of the original trademark entity. So 123 Express Trust doing business as 456508. That 456508 is the same, it is viewed the same legally as the 123 Express Trust. Therefore, the trademark of the 123 Express Trust transferred so long as you are able to show proof that that 508 is linked to that Express Trust. So all the trademark protection carries over.
Okay. Yeah, that makes a lot of sense. So my next question to follow up from that would be, in one of the previous 2 or 4 calls, you were breaking down like the business structure, and you had made reference to a specific intellectual property company that will property the other trusts in our structure. And I was wondering if you could like break down and further elaborate on like how that relationship works. Is it like the same concept, or is there more steps involved?
Okay, so you're basically speaking about how to separate ownership and interest, in short, while still linking it. So in the eyes of the public, the ownership and interest is basically invisible, but it is linked with you. So when it comes to the concept of trademark, and you did that trademark, and by the way, before we start speaking about this, one thing that I was hoping you would ask with that first question was, how come when you do an injunction, you don't speak about the reason why they can't do anything based on trademark or the use of the name? That's what I was expecting you to ask. The reason is because you would have to go into violations of trademark and invoke trademark laws and copyright laws in order for trademark to be applicable as to, well, they can't use your name because you trademarked it. For that to be valid, that concept to be valid, you would have to evoke the legislature's regarding trademark within that injunction. But that's not there at all. But you want to limit the evocation of your rights to just the private contract itself. That way you have more leeway to enforce. And then you always want to tie it to a constitution rather than being limited to the scrutiny of the standard test and element of trademark laws. So anyway, moving on to the second question, when it comes to layering entities, and it's quite sophisticated. So I break it down in the notes that I put down there with the course, but in short, this is what it is. Any business that exists outside, say now, for instance, you have 3 businesses. 1 is the public face, 2 is the licensing companies. That way you can basically make money using the public face and the private side together without anyone knowing about it or being able to basically take whatever you've made as earning. And 3rd is other aspects that you're going to use to run it however you choose. So in this case, we're speaking about the licensure. So business A is what people see in the forefront, selling the kebab and the sandwich and the smoothie and the one of those trucks. Okay, that's business A, that people see the name on the trucks that sells the food. Cool. But business A itself is really not the powerhouse making the money. Business B is. Business B is the one licensing another entity that is not seen at all, that name. So there's an entity between business A and business B. And that entity between business A and business B, the one in between them, is actually the one that is being licensed the name of business A by business B. In other words, so say Russell is the business A that everyone sees. There's something else in the middle. And then there's business B that rents ownership of Russell to that something else in the middle that no one else would ever see. And the licensure agreement is what discloses who that one in the middle is. So if someone goes ahead and sues Russell in the public now, it's just a name that's licensed, rented out by business B to something else in the middle. So for someone to really sue Russell, they will have to go and find that man in the middle that's obtaining the license permission from business B to use Russell. In other words, that something else in the middle is simply doing business as contingent upon the agreement of business B. as Russell. So now, the reason that's done, besides protection or quote asset protection, I don't like using that term because in the age of digital technology, that word asset is very vague and doesn't really hold much ground. But just in the realm of protection, that's one. Besides that, the purpose is also to make money and also to keep as much money, because all proceeds that licensed business A in the public, Russell, that everyone is seeing, is going to business B, because that man in the middle doing business as Russell in the public owes and is encumbered by business B, because Russell is the property of business B being rented through license and agreement by the man in the middle that no one will ever know, but the public only sees Russell. So privacy purpose, protection purpose, and you basically keep all your monies because it's a debt. Everything you're making from that Russell in the forefront is encumbered, so it's owed to whoever's giving you the license to use Russell. That's the short end of it without it getting a little bit too complicated. Do you have any more questions before we move on? All right, I don't know if you can hear me, but I cannot hear you. So maybe you might want to rejoin. I can't hear anything. All right, let me see if I can move on to the next number. The next number I see here, I'm not sure if I call this. I believe it is 281660. 281660. What's going on?
Yeah, you already called me.
Okay, cool. So the next number I saw was 310995. Did I call this number?
Nope. Hi, Haman. Good to hear from you.
Hey.
So I wanted to continue with the notice of settlement we talked about a little while ago.
Okay.
Basically got everything set up. It came out to like over 50 pages because I have all the old debt disputes in there.
Yeah, damn.
My main question was that?
Damn, that's a lot of. That's the lawsuit itself.
Yeah, that's why I was kind of wondering, like, is that? No, that's the notice of settlement.
Oh, that's the notice of settlement and intent to sue.
Yeah. The reason I had.
What the hell?
Yeah, the reason I'm like, because when we last talked about it, you said to put every single letter of the debt disputes.
Yeah.
And then I'm putting it all together. I'm like, that's a lot of exhibits, and it says Exhibit A, Exhibit B, Exhibit C like 4 times. I'm like, is that going to be confusing? I mean, it's all in chronological order.
Okay. So you don't have.
Is that too much?
Do you have double exhibits?
Yeah, there's double exhibits. Because all three exhibits, like the second one has all the first ones, and the third one has like a lot of the first 2.
Wait, say that again?
There's copies of the same exhibits because the debt dispute letters.
Okay.
Like the second one has the first dispute in it. The third one, first and second dispute in it. So it's like there's a bunch. And I put every single page from every single one in the debt notice the way I was trying to do everything in chronological order because you told me every single page.
Yeah.
But now I'm like, that's a lot of pages. So I'm just kind of double checking making sure there's a way I could kind of put it, making it smaller. And
the debt dispute are only like, what, 4 pages total each for each notice? Or like 30 pages?
Yeah, but I put a lot of exhibits, like all the before and afters of my credit report. And
okay, I see. I see.
The
what you're
denial,
saying.
like.
Okay, yeah. I was wondering what could make it that big. Okay, so you put copies of like credit report and their letter and their response and all that stuff. Okay, so within that, the exhibits of the actual dispute versus the exhibits that you're using in the notice of settlement. So what I would do is I would make the exhibits numbers rather than letters. So if notice 1 is exhibit A, notice 2 is exhibit B, I would make, when you add those exhibit A, B, and C into your notice of settlement, I will make all those now as a whole exhibit 1. So I would make exhibits based on phase and month. So I'll put exhibit 1 parentheses February 2025, exhibit B parentheses March 2025. So I would do it by month. But I would make it this time chronological order of numbers rather than letters, so it doesn't look duplicated or confusing. Do you see what I'm saying?
That's a good idea. Yeah, so
Okay.
change all the letters to numbers, and if it's the specific debt dispute, put the month and year that dispute was sent
Right.
with those numbers.
Right, exactly. You got it.
Okay. Got it. Okay. That's good. That's good. And then next question will be for the notice of withdrawal. So it says, there's part of it that says, like, please categorize the above referenced documents as relating to unauthorized use of the info, like, then it has the employee social address. But then it says, from the year to year as such, and update any file that you hold. If I technically didn't send anything to the IRS, and it was kind of what we talked about, how it was the employer who did that,
Yeah.
do I still need that, update that to year? Because I didn't really do anything, so I'm not sure if I need that part or if I would change that.
Yeah, so that's the reason why those were left highlighted as blue. So that part, only add the years that you've done anything that you need to modify or fixed or get removed. So even if it's just 1 year, then
Got it. So if
just put it there.
got it.
So
So
instead
if
of,
I got a letter that was like, oh, go ahead.
I was just gonna say, instead of from year to year, just put during years, fill in the blank.
Years, okay. So I got one letter 2023, and then the next one 2024. So I'll just put during the years, and then put those 2 years, right?
Exactly. Right.
Got it. Okay. Next, our last question is, so for the affidavit of identity theft as a police report, so
Yeah.
that template, so I'm just fixing it, filling it out, and then I'm sending that along, or am I actually taking that to like a police station and I don't know, I've never done like a police report.
Okay,
I'm just an
okay.
FTC report.
Okay, yeah. So with that affidavit of identity theft, you don't take it to the police station. You only get a copy of the police report